This is unacceptable. You cannot speak to people this way.
You're making a huge mistake. Stop this right now.
Sir, we have authority to detain for HOA violations. Step back. My 13-year-old niece was handcuffed in the back of their security vehicle, crying, having a panic attack triggered by uniformed officers restraining her the same way police restrained her father before killing him 2 years ago. I'm a constitutional law attorney. You have zero legal authority. Release her now or face federal civil rights charges. The officer's face went pale. My name is Marcus Chen. I'm a civil rights attorney who spent 12 years prosecuting Fourth Amendment violations, unlawful detention, and police misconduct. I've won $47 million in settlements from law enforcement agencies that handcuffed people without legal authority. The HOA security officers who grabbed my niece for skateboarding just committed the exact constitutional violations I specialize in destroying. If you've ever promised a grieving mother you'd protect her child, and then watched that child be handcuffed by authority figures who had no legal right to touch her, then hit subscribe now. Let me tell you why this matters more than HOA violations or covenant enforcement. 2 years ago, my brother-in-law was killed during a traffic stop when police detained him without reasonable suspicion, escalated to force, and shot him claiming he matched a description. The shooting was ruled unjustified. Qualified immunity protected the officers from prosecution. But I represented my sister in the civil rights lawsuit. We won $3.2 million. It didn't bring Maya's father back. It didn't erase the fact that my 11-year-old niece watched police kill her dad over a traffic stop that never should have happened. It didn't stop the PTSD, the nightmares, the panic attacks triggered by anyone in uniform with authority to restrain her. This summer, Maya's staying with me while her mother recovers from medical issues. My sister asked me one thing: keep her safe. Don't let anyone hurt her the way they hurt her father. I promised. Yesterday afternoon, HOA security officers grabbed Maya, handcuffed her, detained her in their patrol vehicle for 41 minutes, and traumatized a child who'd already lost her father to unlawful detention. They grabbed her for skateboarding near the community park. The skateboarding her therapist prescribed as grief processing after watching her dad die. Put restraints on her, the same type of restraints that were on her father when he was killed. Held her without calling me, without legal authority, without understanding they just violated every constitutional protection I've spent my career enforcing. When the neighbor called me, I was 3 blocks away. By the time I arrived, Maya had been detained for 38 minutes. The HOA security vehicle looked like a police car, white with blue stripe, official emblem, light bar on top. Maya sat in the back seat, handcuffed, crying, hyperventilating through the same panic attack I'd watched her have dozens of times since her father's death. 2 men in security uniforms stood outside, badges, radios, handcuffs on their belts. They looked professional, official, authoritative. They had no idea they'd just committed federal civil rights violations against the niece of the attorney who'd spent 12 years destroying law enforcement agencies for exactly this kind of constitutional overreach. I approached the vehicle, knocked on the window. Maya looked up, face streaked with tears, eyes wide with the same terror I'd seen when she watched her father die. The officers stepped between me and their vehicle. "Sir, we're conducting an HOA security investigation. Please step back." "That's my 13-year-old niece you have in handcuffs. Release her immediately." "She was skateboarding in violation of community rules and resisted our lawful order to stop. We have authority to detain pending verification of your resident status." You have zero legal authority to detain anyone. You're private security, not law enforcement. Those handcuffs constitute false imprisonment of a minor. Remove them now." The officer's hand moved toward his radio. "Sir, if you interfere with HOA security operations..." "I'm Marcus Chen, constitutional law attorney specializing in unlawful detention. You just grabbed my niece, handcuffed a trauma survivor whose father was killed by police, and held her without parental notification for 41 minutes. You've committed false imprisonment, unlawful seizure under the Fourth Amendment, and if you don't release her right now, kidnapping of a minor." His confidence cracked. "We were following HOA President Prescott's security protocols. Those protocols are unconstitutional, and the fact that you targeted a biracial girl for an activity white teenagers engage in without consequences creates civil rights liability I will absolutely pursue." They removed the handcuffs. Maya ran to me, collapsed in my arms, shaking so violently I could feel her heart racing. She whispered the same thing she'd said the day her father died. "I was so scared. I thought they were going to hurt me." I held my niece while she had a panic attack triggered by the same authority abuse that had killed her father. And I made the promise I'd made to my sister 2 years ago. This will not stand. Where are you watching from? Because what happened when HOA security grabbed the wrong attorney's niece proved that unlawfully detaining minors triggers the exact federal lawsuit I've spent 12 years winning. Diana Prescott's security force had 48 hours before I destroyed them. The skateboarding violation that led to Maya's detention started 6 weeks earlier when Diana Prescott issued her first warning. Notice: skateboarding prohibited in all community park areas per section 15.3, recreational equipment restrictions. Violation observed: minor resident using skateboard near basketball court. Warning issued: future violations subject to $500 fine and equipment confiscation. I reviewed section 15.3 that evening. The covenant restricted motorized recreational vehicles from park spaces. Skateboards aren't motorized. The HOA president was inventing restrictions that didn't exist in the governing documents. I called the HOA office the next morning. "This violation misinterprets the covenant. Section 15.3 only prohibits motorized equipment. My niece's skateboard doesn't qualify." The secretary put me on hold, returned with Diana's response. "Mrs. Prescott has determined that all recreational equipment creates liability exposure and community disruption. The violation stands. Continued skateboarding will result in enforcement action." Enforcement action against a 13-year-old? HOA security has authority to address all covenant violations, regardless of violator's age. I filed formal contests citing the actual covenant language, explaining that skateboarding was Maya's therapist-prescribed grief processing after losing her father to police violence. The security director's response doubled down. "Contest denied. Minor resident Maya Chen is hereby prohibited from skateboarding in any community space. Additionally, mandatory security compliance meeting scheduled. Both guardian and minor must attend to address disrespectful use of facilities and ensure understanding of rules." That's when I started researching Diana's enforcement history in Lakewood Estates. What I found made my blood run cold. The Morrison family, 2023, 15-year-old black son detained by HOA security for suspicious behavior, riding his bike through the neighborhood at dusk, held for 30 minutes, questioned without parents present, released with warning about loitering. The Patel family, 2023, 14-year-old daughter stopped by security for unauthorized gathering, sitting in the park with 2 friends, made to show identification, questioned about where she lived. escorted home by uniformed officers. The Rodriguez family, 2024. 16-year-old twins detained for excessive noise, playing basketball at the community court at 3 p.m. on a Saturday. Security confiscated their basketball, issued violations, threatened trespassing charges if they returned. The Washington family, 2024. 13-year-old son stopped while walking to a friend's house, questioned about suspicious activity, searched without consent when security claimed they smelled marijuana. Nothing found. Family filed complaint. Diana responded by issuing parking violations and lawn maintenance citations until they sold their house 3 months later. 12 families total over 18 months. Every single detained teenager was a person of color. All were stopped for activities: riding bikes, playing basketball, sitting in parks, walking through the neighborhood, that white teenagers engaged in without any intervention. Diana had created an HOA security force that operated as private police with detention authority, handcuffs, and patrol vehicles. But unlike actual police, they had no constitutional constraints, no oversight, no training in civil rights protections, and she was systematically using them to target young people of color. I found internal HOA communications that made the pattern explicit. An email from Diana to her security team. Increased vigilance needed regarding unsupervised minors in community spaces. Parents of teenagers must understand that Lakewood Estates maintains family-friendly standards. Proactive security presence discourages disruptive behavior. Family-friendly standards was code. Proactive security presence meant stopping kids of color while white teenagers played freely. Maya fit the profile perfectly. Biracial, from outside the neighborhood, engaging in activity the HOA president had decided to criminalize. I also discovered how Diana funded her private police force. Special assessment imposed without proper homeowner vote, justified as enhanced community safety measures. $65,000 per officer, 3 officers total. Nearly $200,000 annually from HOA dues, funding a security operation that had no authority in the covenants. That evening, Maya came home from attempting to skateboard at the public sidewalk just outside Lakewood Estates. Uncle Marcus, those security guys followed me in their car. Told me I was violating HOA rules even though I wasn't on HOA property. Said if they saw me again, they'd detain me for trespassing. They threatened to detain you? They said they had authority to arrest people who violated community standards. Is that true? I pulled Maya close, felt her trembling at the memory of uniformed men with badges threatening her freedom. No, sweetheart. They have zero legal authority to detain anyone. What they're doing is called false imprisonment, and it's a crime. But they look like police. They have handcuffs and uniforms and everything. That's exactly the problem. They're pretending to be law enforcement without any of the constitutional limits that constrain actual police. 2 days later, the HOA president escalated from threats to action, and Maya was grabbed, handcuffed, and held in that security vehicle for 41 minutes while I raced to save her from the same kind of authority abuse that had killed her father. The security director thought she could operate a private police force targeting children of color. She'd just detained a civil rights attorney's niece. And she had no idea what happens when you unlawfully restrain the family member of someone who destroys unconstitutional detention operations for a living. Officer Tom Bradley appeared at my door the evening after Maya's detention, still wearing his HOA security uniform, looking like a man who'd been wrestling with his conscience for months. Mr. Chen, I'm one of the officers who was there yesterday when your niece was detained. I need to talk to you about what's happening with HOA security. I recognized him. Retired police sergeant, 28 years on the force, now working Diana's private security operation. He stood on my porch, shifting his weight from foot to foot, hands clenching and unclenching at his sides, unable to maintain eye contact for more than a few seconds. What about it? What we did yesterday, detaining your niece, putting her in handcuffs, holding her for 45 minutes, that wasn't right. His voice cracked. I knew it wasn't right while we were doing it, but I followed orders anyway. Why are you telling me this? Bradley's hands shook as he pulled them from his pockets, then shoved them back in. He looked over his shoulder at his car, then back at me, jaw working like he was forcing himself to speak. Because I was a cop for 28 years. I know what lawful detention looks like. I know what constitutional authority requires. And what Diana has us doing isn't law enforcement, it's intimidation, dressed up as security. Then why do it? Because I need this job. He finally looked at me directly, eyes red-rimmed. My daughter's a sophomore at UVA, tuition $65,000 a year. Diana pays me the same amount to patrol Lakewood Estates. I can't afford to lose that income. So you handcuff 13-year-olds to keep your paycheck? His face flushed with shame. I told Diana we shouldn't detain minors without parental notification, that using handcuffs on kids for skateboarding violations crossed a line. She said if I questioned her security protocols again, she'd file a complaint with the state licensing board claiming I was insubordinate and unsuitable for security work. That complaint would tank any future employment in this field. She threatened your license? Last year, another officer, Mike Chen, no relation to you, objected to Diana ordering us to stop and question a black teenager who was just walking through the neighborhood. Mike said it was racial, profiling, that we had no reasonable suspicion. Diana fired him within a week and filed a licensing complaint, claiming he'd used excessive force during an unrelated incident 6 months earlier. The complaint was dismissed, but Mike couldn't find security work for 8 months because of the investigation cloud. Bradley's hands trembled as he pulled out his phone, showed me saved emails. I've been documenting everything because I knew eventually someone would fight back. I have emails from Diana explicitly ordering us to increase surveillance of minority teenagers, training materials instructing us to use proactive detention for suspicious behavior, which is code for stopping kids of color. Documentation that she personally directed your niece's detention after learning you challenged her authority. She targeted Maya specifically. After you filed that contest about the skateboarding violation, Diana sent an email to all security officers. Guardian Marcus Chen has a demonstrated pattern of undermining HOA authority. Increased monitoring of associated minor resident recommended. Any violations to be addressed immediately with full enforcement protocols, including detention if necessary. She ordered you to grab my niece as retaliation? Bradley nodded, face twisted with guilt. I was the one who suggested we just give her a warning. The other officer, Jake Morrison, said Diana had been clear that Chen family requires firm enforcement to establish respect for security authority. When your niece tried to leave on her skateboard, Jake grabbed her. I put on the handcuffs because I was following orders like I did for 28 years as a cop. Why come forward now? Because last night I went home and my daughter asked why I looked upset. I told her about detaining a 13-year-old for skateboarding. She asked if the girl was white or black. Bradley's voice broke completely. When I said biracial, my daughter looked at me like I was someone she didn't recognize. She said, "Dad, you used to be one of the good cops. What happened? He wiped his eyes, shoulders hunched under the weight of complicity. I can't testify publicly, can't risk my job or my daughter's education, but I can give you evidence. Emails, training materials, documentation of every teenager we've detained over the past year. Every single one was a person of color. Every single detention violated constitutional protections. And Diana personally directed all of it. You understand what you're giving me? Proof that Diana Prescott created an unconstitutional private police force specifically to target families of color and drive them out of Lakewood Estates. Bradley handed me a USB drive. Everything's on here. Use it to stop her, because I can't keep handcuffing kids and pretending I'm just following security protocols. After he left, I reviewed the drive's contents. Hundreds of pages of emails, training documents, and detention records, proving systematic constitutional violations targeting youth of color. Officer Bradley had just handed me the evidence that would destroy Diana's security operation and expose her discriminatory enforcement. The conflicted witness had chosen conscience over paycheck, and the HOA president had no idea her own security officer had just become my star witness. I called the HOA office the morning after receiving Bradley's evidence, requesting meeting with Diana to discuss Maya's unlawful detention. The secretary scheduled me for 2 p.m. that afternoon at the HOA administrative building. Diana's office was decorated like a command center. Security monitor showing live feeds from cameras throughout Lakewood Estates, framed certificates from her corporate security director days, photos of her with local law enforcement officials. She sat behind her desk in a crisp blazer, exuding the confidence of someone who'd built power through intimidation and never faced real consequences. Mr. Chen, I understand you're upset about yesterday's incident with your niece, but HOA security followed proper protocols. Your security officers handcuffed a 13-year-old and held her for 45 minutes. That's not protocol. That's false imprisonment. The HOA president leaned back, expression hardening. Your niece was skateboarding in violation of community rules, fled when security attempted to address the violation, and was briefly detained to verify resident status and ensure compliance. Standard security procedure. You have no legal authority to detain anyone. Your officers are private security, not law enforcement. Our officers are licensed, trained, former police professionals operating under HOA authority to enforce community standards and maintain safety. Diana pulled out a binder, flipped to a page. Section 22.7 grants the board authority to implement necessary security measures to protect property values and resident safety. Our security patrol operates under that authority. Section 22.7 doesn't authorize detention, handcuffs, or physical restraint. You created a private police force with powers that exceed any authority granted in the covenants. Mr. Chen, I've been HOA president for 3 years. I've implemented security measures that have reduced property crimes by 40% and maintained community standards that preserve our property values. Residents appreciate knowing their neighborhood is protected by professional security. Protected from 13-year-olds on skateboards? Her jaw tightened. Protected from individuals who disregard community rules and demonstrate disrespect for authority. Your niece was warned multiple times. She chose to continue violating restrictions. Security had every right to address that behavior. By handcuffing a child? By detaining someone who resisted lawful security orders. Age doesn't exempt residents from consequences. The security director's tone shifted to barely contained anger. Frankly, Mr. Chen, your niece's behavior reflects poorly on your guardianship. A properly supervised child wouldn't be skateboarding in prohibited areas or fleeing from security officers. You're blaming a trauma survivor for having a panic attack when uniformed officers grabbed her? I'm stating that parents or guardians who teach children to respect authority don't have these problems. Perhaps if you'd brought her to the compliance meeting as requested, security education could have prevented yesterday's unfortunate incident. The unfortunate incident where your officers committed constitutional violations? Diana stood, signaling the meeting's end. Mr. Chen, I've tried to be accommodating, but your continued challenges to HOA authority and your niece's repeated violations leave me no choice but to escalate enforcement. Effective immediately, your niece is banned from all community facilities. If she's observed on HOA property, she'll be detained for trespassing and local police will be notified. You can't ban a resident from community property. I can restrict access for individuals who demonstrate pattern of rule violations and disrespect for security personnel. Additionally, your household is now subject to enhanced compliance monitoring. Any violations will result in maximum fines and immediate enforcement action. You're retaliating because I challenged your authority. I'm protecting this community from residents who undermine the security measures that keep Lakewood Estates safe and desirable. She walked to her door, opened it. This meeting is concluded. Future communications should go through our HOA attorney. I stood slowly, met her eyes. Diana, I'm a constitutional law attorney. I specialize in Fourth Amendment violations and unlawful detention. What your security force did to my niece yesterday violates every constitutional protection I've spent 12 years enforcing. For the first time, uncertainty flickered across her face. Your officers handcuffed a minor without legal authority, detained her without parental notification, and held her for 45 minutes based on a covenant interpretation that exceeds your governing documents. That's false imprisonment, unlawful seizure. And when combined with your pattern of targeting youth of color while white teenagers face no enforcement, it's discriminatory prosecution that violates civil rights law. Are you threatening legal action? I'm informing you that unlawfully detaining my niece triggered the exact federal civil rights case I prosecute professionally. You have 48 hours to disband your security force and cease all detention operations before I file for emergency restraining order. Diana's confidence returned, cold and absolute. Mr. Chen, I have dealt with difficult residents before. Legal threats don't intimidate me. Our security operations are fully authorized, properly implemented, and essential to community safety. If you file frivolous lawsuits, you'll face counterclaims for harassment and abuse of process. Then I'll see you in federal court. I walked out of her office, knowing the HOA president had just made her position clear. She believed HOA authority trumped constitutional protections, that her security force could operate with detention powers, and that threatening a civil rights attorney with counterclaims would somehow intimidate me into backing down. She had 48 hours before learning how catastrophically wrong she was. The security director thought licensed former cops gave her operation legitimacy. She didn't know that operating under color of law without constitutional authority creates the exact civil rights liability I'd spent my career imposing on government officials who abuse power. Diana Prescott's private police force was about to face federal judicial review, and she had no idea what happens when unconstitutional detention operations encounter an attorney who knows exactly how to destroy them. I spent the next afternoon at the basketball court area where Maya had been grabbed. documenting HOA securities operations with the clinical precision I'd learned prosecuting constitutional violations for 12 years. Arrived at 3 p.m., prime after-school hours when teenagers gathered. Within 20 minutes, I witnessed the pattern that Officer Bradley's documents had described. 3 white teenagers skateboarding near the basketball court. Security patrol vehicle drove past. No interaction, no stops, no detention. 15 minutes later, 2 black teenagers arrived with a basketball, started shooting hoops. The security vehicle circled back within 5 minutes. 2 officers exited, approached the teenagers. IDs, please. Need to verify your residence. The teenagers, couldn't have been older than 14, pulled out school IDs, looking nervous. These don't show addresses. You live in Lakewood Estates. Yes, sir. My house is on Maple Drive. We'll need to verify that. Wait here while we check resident database. The officers returned to their vehicle. The teenagers stood waiting, no longer playing basketball, just standing in visible anxiety while uniformed men with badges ran background checks on children playing in their own neighborhood park. 10 minutes passed. The officers finally returned. You're clear, but basketball noise needs to be kept reasonable. We've had complaints about excessive volume. We just got here. Consider this a warning. Keep it down or we'll issue noise violations. The teenagers left, didn't resume playing, just walked away from the court they'd been using minutes earlier. The white teenagers continued skateboarding without any interaction. I documented everything: times, descriptions, disparate treatment of identical activities based solely on race. Then I did what civil rights attorneys do when building constitutional cases. I reviewed the governing documents to identify the legal technicality that would destroy Diana's defense, pulled out Lakewood Estates' Declaration of Covenants, Conditions, and Restrictions. The master document establishing HOA authority. Read every section related to enforcement, security, and board powers. Found exactly what I needed in Section 22.7. The provision Diana had cited as authorization for her security force. The Board of Directors may implement necessary security measures to protect property values and resident safety, including but not limited to lighting, cameras, and access control systems. Lighting, cameras, access control, no mention of security personnel, no authorization for patrol vehicles, no grant of detention authority, no provision allowing handcuffs, stops, searches, or physical restraint of residents. Diana had created an entire private police operation based on a covenant section that authorized installing security cameras. The security force wasn't just unconstitutional, it was ultra vires. Beyond the legal authority granted in the HOA's governing documents. Every detention, every stop, every handcuffing was not only a Fourth Amendment violation, but also an unauthorized act for which Diana and her officers could be held personally liable. I pulled out my phone, photographed the relevant covenant sections, then researched Virginia HOA law, found the controlling statute, Virginia Property Owners Association Act, Section 55, 1834. Powers of association limited to those expressly granted in declaration, or reasonably implied as necessary to exercise granted powers. Security cameras are granted. Detention authority is not granted and cannot be reasonably implied from camera installation. The entire operation was legally baseless. I compiled my findings into preliminary legal analysis, constitutional violations, Fourth Amendment unlawful seizure, handcuffing residents without legal authority, equal protection violations, discriminatory enforcement based on race, potential 14th Amendment due process violations, detention without hearing or notification, Ultra-vires operation. Security force exceeds any authority granted in covenants. Special assessment funding it imposed without proper vote. Detention powers never authorized by governing documents. Personal liability exposure. Diana and officers acting outside scope of HOA authority creates individual tort liability for false imprisonment, battery, unwanted physical contact, intentional infliction of emotional distress. State licensing violations. Security guards licensed for observation, reporting, not detention as arrest, exceeded licensing authority with every handcuffing. I had everything needed for emergency restraining order. Constitutional violations, legal technicality showing lack of authority, pattern evidence of discrimination, personal liability exposure that would terrify the HOA's insurance company. As I prepared to leave the basketball court, another interaction unfolded. A Hispanic teenager arrived on a bicycle, started riding around the court perimeter. Security vehicle appeared within minutes. "Stop. Need to see identification." The teenager looked confused. "I live here. I'm just riding my bike. ID, now." I approached, phone camera recording openly. "Excuse me, officers, I'm documenting your interaction. What's the basis for this stop?" The lead officer recognized me. "Mr. Chen, this doesn't concern you. I'm witnessing what appears to be a stop based solely on this teenager's ethnicity. That concerns me professionally. We're conducting routine security verification of a child riding a bicycle in a community park, while 3 white teenagers skateboard behind you without any routine verification." The officer's face flushed. "Sir, if you interfere with security operations, I'm observing, recording, and documenting disparate treatment that constitutes discriminatory enforcement. Continue your routine verification while I capture evidence for the civil rights lawsuit I'm filing." They released the teenager without further questioning. But I had what I needed: live documentation of racially discriminatory stops, proof that Diana's security force operated with detention mentality, and legal analysis showing the entire operation exceeded HOA authority. The HOA president thought covenant language about security measures authorized her private police force. She'd just created the legal technicality that would destroy her defense before we ever reached constitutional arguments. Diana's security operation was ultra vires, and every detention was a personal tort. She had 36 hours before learning that in federal court. I found Maya in her room that evening, sitting on her bed, staring at the skateboard leaning against the wall. The skateboard she hadn't touched since the detention. "Uncle Marcus, I keep having the same nightmare. The security officers grabbing me, the handcuffs clicking, being trapped in their vehicle. It feels exactly like when..." Her voice broke. "When I watched Dad get arrested before they shot him." I sat beside my niece, felt her trembling the way she'd trembled for months after her father's death. The therapist said skateboarding was supposed to help me process Dad's death, that it would give me control when everything else felt chaotic. But now, every time I look at my board, I just see those officers grabbing me. "Maya, what they did to you was unlawful, unconstitutional, and I'm going to make sure they can never do it to anyone else." "How?" "They have uniforms and badges and cars that look like police. They told me they had authority to arrest people who broke rules. They lied. Private security has no arrest authority, no detention powers, no legal right to handcuff anyone." I pulled out my laptop, showed her the covenant analysis I'd compiled. The HOA president created this security force based on a covenant section that only authorizes cameras and lighting. Everything they've done exceeds the authority, granted in the governing documents. So, it's illegal? It's ultra vires, beyond their legal power, which means every time they detained someone, handcuffed someone, searched someone, they weren't acting under HOA authority. They were committing personal torts, false imprisonment, battery, civil rights violations. Maya looked at me with eyes too old for 13. Are you going to sue them? I'm filing an emergency motion for restraining order tomorrow morning, asking a federal judge to immediately prohibit HOA security from detaining, handcuffing, or physically restraining any resident pending full constitutional review. Will it work? The evidence is overwhelming. Constitutional violations captured on video, pattern of discriminatory enforcement affecting 12 families, security operation that exceeds governing document authority, unlawful detention of a minor trauma survivor. Any federal judge will grant the restraining order within 48 hours. My sister Rachel called while Maya and I were talking. She'd seen the photos I'd sent of Maya's detention, her daughter in handcuffs, crying, traumatized. Marcus, I trusted you to keep her safe. You promised she wouldn't be hurt by authority figures the way her father was. Rachel, I know. I failed. I should have... No, let me finish. Her voice strengthened. You didn't fail. You're doing exactly what needs to be done. You're using your expertise to make sure what happened to Maya and her father doesn't happen to other children. That's honoring the promise. That's protecting her by changing the system. She's having nightmares again, won't touch her skateboard. The PTSD I thought was healing has come back worse than before. Because uniformed men with badges grabbed her and put her in restraints. The exact trauma that killed her father. Rachel's voice broke. But you're a civil rights attorney, Marcus. You've spent 12 years destroying people who do this. Destroy these people. Make them pay for traumatizing my daughter. And make sure no other child in that neighborhood lives in fear of being detained for playing in their own community. After we hung up, I spent the next 6 hours preparing the emergency motion for restraining order. Legal standard, likelihood of success on the merits, irreparable harm, balance of equities, public interest. Likelihood of success, overwhelming. Fourth Amendment violations, unlawful seizure without legal authority. Ultra vires operation, security force exceeds covenant authority. Discriminatory enforcement, pattern targeting youth of color, false imprisonment of minor, 41-minute detention without parental notification. Irreparable harm. Children continue to be detained, handcuffed, traumatized by unconstitutional security force. Maya's PTSD worsening. Other families living in fear. Balance of equities. Residents' constitutional rights outweigh HOA's interest in unauthorized security operations. Public interest. Preventing. Private organizations from creating police forces without constitutional constraints serves compelling public interest. I attached exhibits, photos of Maya in handcuffs, medical records documenting her PTSD, Officer Bradley's emails showing discriminatory targeting, covenant analysis proving ultra-vires operation, pattern evidence of 12 families affected, video of security stopping Hispanic teenager while white teenagers skateboarded freely. The motion was bulletproof. Filed it electronically at 11:47 p.m., requested emergency hearing within 48 hours. The federal court clerk called at 8:15 a.m. the next morning. Mr. Chen, Judge Morrison has reviewed your emergency motion. Hearing scheduled for 2 p.m. today. Respondents have been notified. 12 hours from filing to judicial review. I called Maya into my office. The hearing is this afternoon, A federal judge will decide whether HOA security can continue detaining residents or if they're immediately prohibited from all physical enforcement. Will I have to testify? Not at this hearing, but your photos, you in those handcuffs, will be evidence. The judge will see exactly what they did to you. Maya looked at her skateboard, still untouched in the corner. If the judge stops them from grabbing kids, will I be able to skateboard again without being scared? That's exactly why I'm doing this, sweetheart. So, you and every other child in Lakewood Estates can use community spaces without fear of being detained by people who have no legal authority to touch you. If you've ever watched your niece have panic attacks because uniformed officers restrained her the same way police restrained her father before killing him, stay with me. Because what a federal judge said when reviewing evidence of private security handcuffing a 13-year-old didn't just grant the restraining order. It destroyed the HOA president's entire defense and triggered investigations that changed Virginia law. Diana Prescott had 12 hours before learning that operating an unconstitutional security force triggers federal judicial intervention she couldn't survive. And she still had no idea her own officer had provided the evidence that would end her. Officer Tom Bradley called me 3 hours before the federal hearing, voice shaking with barely controlled fear. Mr. Chen, Diana knows I talked to you. She just called an emergency security meeting and accused me of providing confidential information to hostile parties. She's threatening to fire me and file licensing complaints unless I recant everything. Can you meet me before the hearing? She's watching. I can't be seen with you. He paused. But there's a coffee shop 2 blocks from the courthouse. Busy, public. I'll be there at noon. I arrived early, sat in the back corner with clear view of the entrance. Bradley showed up at 12:05, wearing civilian clothes instead of his security uniform. Baseball cap pulled low, moving like someone afraid of being followed. He slid into the seat across from me, hands trembling as he set down his coffee cup. Diana called me into her office this morning, showed me your restraining order filing, asked if I'd provided you with internal security documents. His voice dropped to barely a whisper. I denied it, but she knows. She said if evidence from HOA security files appears in federal court, she'll know exactly who leaked it, and I'll face criminal charges for theft of proprietary information. You can't steal evidence of crimes being committed. She doesn't care about legal technicalities. She cares about destroying anyone who threatens her authority. Bradley pulled out his phone, showed me a text from Diana sent an hour earlier. Officer Bradley, your loyalty is being questioned. Prove you're committed to Lakewood Estates security or face immediate termination and licensing review. Your choice. She's trying to intimidate you into silence. It's working. I have a daughter in college. Mr. Chen, I can't afford to lose this job or my security license. I can't risk Diana's retaliation. His hand shook harder. But I also can't keep pretending what we did to your niece was legitimate security work. He leaned forward, voice breaking with suppressed guilt. After we detained Maya, I went home and couldn't sleep. Kept seeing her face when we put those handcuffs on. She's 13, same age as my daughter when I started this job. And I restrained her, put her in our vehicle, held her for 45 minutes because Diana ordered me to target your family. Why come forward now if you're afraid of retaliation? Because this morning, Diana sent new security protocols to all officers. Bradley showed me an email on his phone. Enhanced Enforcement Directive. Effective immediately, security personnel authorized to use necessary physical restraint to prevent resistance during detention operations. Officers may handcuff any resident who demonstrates non-compliance with lawful security orders, including minors age 12 and above, extended detention periods approved for investigative purposes up to 2 hours without external notification. I read it twice, fury building with every word. She's authorizing her security force to handcuff children as young as 12 and hold them for 2 hours without notifying parents. She's doubling down, expanding detention authority instead of scaling back. Bradley's voice cracked completely. Mr. Chen, I've been a cop for 28 years. I know what lawful detention requires. This isn't security. It's kidnapping with official-looking uniforms. Will you testify at the hearing? Tell the judge what Diana ordered you to do? He looked at his phone, at Diana's threatening text, then at me with eyes that had made a choice between paycheck and conscience. If I testify, I lose everything: my job, my income, possibly my license if Diana follows through on her threats. My daughter might have to leave college because I can't pay tuition. If you don't testify, more children get handcuffed by a security force that has no legal authority and is now authorized to hold 12-year-olds for 2 hours. Bradley was quiet for a long moment, shoulders hunched under the weight of complicity and consequence. I'll testify, but I need something in writing: protection from retaliation, guarantee that my licensing won't be affected, assurance that cooperating with federal court won't destroy my career. I can't promise Diana won't try to retaliate, but I can promise that testifying against unconstitutional detention protects you legally. You're reporting civil rights violations. That's protected activity under whistleblower statutes. What about my job? You'll lose it. Diana will fire you the moment you testify against her. But wrongful termination for reporting constitutional violations creates additional liability for the HOA. You'll have claims for retaliation, and the settlement will likely exceed what you'd earn in remaining years of this contract. He pulled out a USB drive, different from the one he'd given me before. This is everything from this morning. Diana's new protocols authorizing extended detention of children, her emails ordering me to recant my statements to you, text messages threatening my employment and license, and recordings from my body camera the day we detained Maya. You recorded the detention? All HOA security wears body cameras. Diana requires it for liability protection. She doesn't know I kept the footage instead of submitting it to her for review. His hand steadied as he made his decision final. The recording shows everything: me objecting to handcuffing Maya, Jake Morrison saying Diana ordered full enforcement, your niece crying and asking for you, us holding her for 41 minutes while she had a panic attack. All of it. This is everything we need. Then use it, because I'm done being the guy who handcuffs kids to keep his paycheck. Bradley stood, pulled his security badge from his pocket, set it on the table. I'm resigning effective immediately. I won't work another day for Diana Prescott's private police force, and I'll testify to every constitutional violation I witnessed, every discriminatory order I followed, and every child I helped traumatize because I was afraid to lose my job. The judge will want to hear directly from you about Diana's orders. I'll be at the courthouse at 2 p.m. I'll tell the judge exactly how the HOA president created an unconstitutional security operation, systematically targeted youth of color, and personally ordered the detention of your niece as retaliation for you challenging her authority. After he left, I reviewed the new evidence: body camera footage, threatening emails, protocols authorizing detention of 12-year-olds. Officer Bradley had just transformed from conflicted witness to star testimony, and Diana had no idea her own security officer was about to destroy her defense in federal court. The HOA president thought threatening Bradley would silence him. She'd just guaranteed he'd testify. I spent the 2 hours before the federal hearing in my law office, preparing the constitutional case with the precision I'd used for 12 years prosecuting civil rights violations. Started with the legal framework that would destroy Diana's security operation. Fourth Amendment analysis. The right of the people to be secure in their persons against unreasonable searches and seizures shall not be violated. Private security handcuffing residents, seizure of person, no warrant, no probable cause, no reasonable suspicion of crime. Seizure based solely on HOA covenant interpretation, jerks constitutionally unreasonable. The fact that Diana's officers were private rather than government actors didn't exempt them. They were operating under color of law by wearing badges, driving patrol vehicles, and claiming official authority to detain. Supreme Court precedent. When private actors exercise powers traditionally reserved to government, arrest, detention, use of force, they're subject to constitutional constraints. Diana's security force looked like police, acted like police, detained people like police. Constitutional protections applied. Next, ultra-virus analysis. Virginia law required HOA powers to be expressly granted in declaration or reasonably implied as necessary. Lakewood Estates Covenants, Section 22.7. Board may implement security measures including lighting, cameras, and access control. Lighting, Choan granted. Cameras, Choan granted. Access control, Choan granted. Hiring armed security with detention authority, not granted and not reasonably implied from installing cameras. The entire security operation exceeded HOA's legal authority, making every detention an unauthorized act for which Diana and officers were personally liable. Third, pattern evidence of discrimination. Compiled data from Officer Bradley's files, 23. Detention incidents over 18 months, 23 of 23 detainees were people of color. 0 white teenagers detained despite engaging in identical activities. Activities triggering detention: skateboarding, playing basketball, riding bikes, sitting in parks, walking through neighborhood statistical analysis. 100% of detentions targeting non-white youth, which are discriminatory enforcement that violates Equal Protection Clause and Fair Housing Act. Fourth, personal liability exposure. False imprisonment, unlawful detention. $50,000, $500,000 per incident. Battery, unwanted physical contact, handcuffing. $25,000, $250,000 per incident. Intentional infliction of emotional distress, traumatizing PTSD survivor. $100,000, $1,000 civil rights violations, 42 U.S.C. 1983. Punitive damages available multiply by 23 incidents. Potential liability exceeding $10 million. Diana and her officers operated without qualified immunity, without HOA authority, without constitutional justification. Every detention created personal tort liability. I also prepared the insurance angle I knew would terrify the HOA board. Called Lakewood Estates Liability Insurance Carrier, spoke with their risk management director. This is Marcus Chen, attorney for residents affected by HOA security operations. I'm providing notice of pending federal civil rights lawsuit involving systematic detention of minors, discriminatory enforcement, and false imprisonment. The complaint will be filed within 30 days, seeking damages exceeding $8 million. What kind of security operations? HOA president created private police force that has detained 23 residents, all people of color, using handcuffs and physical restraint without legal authority. Most recent incident involved 41-minute detention of a 13-year-old trauma survivor, triggering emergency restraining order hearing in federal court today. Silence on the line then. Our policy specifically excludes coverage for law enforcement activities, intentional acts, and civil rights violations. If HOA security is operating as de facto police force, those claims won't be covered. I'm aware, which is why HOA board members should know they're facing 8-figure liability with no insurance coverage for Diana's security operations. We'll be reviewing the policy and conducting immediate investigation. If security force is operating beyond scope of authorized activities, we'll likely terminate coverage entirely. Perfect. Insurance pressure would force board action even before the judge ruled. I also drafted media strategy for after the hearing, contacted local news, national civil rights organizations, social media advocacy groups, prepared press release, 13-year-old trauma survivor, handcuffed by HOA security for skateboarding, father killed by police 2 years ago in unlawful detention, federal court hearing today on emergency restraining order. The story had everything media needed: child victim, racial discrimination, authority abuse, constitutional violations, dead father parallel. If the judge granted the restraining order, media coverage would ensure Diana's security operation became national scandal. At 1:30 p.m., I gathered my evidence files and headed to federal court. Officer Bradley was already there, sitting on a bench outside the courtroom, still in civilian clothes, looking like a man who'd made peace with losing everything to do what's right. "You ready?" I asked. "I've been ready since I put handcuffs on your niece and watched her have a panic attack in our vehicle. Ready to tell a judge exactly what Diana ordered us to do and why every bit of it violated constitutional protections I swore to uphold for 28 years. At 1:55 p.m., Diana arrived with her HOA attorney, expensive suit, briefcase full of defenses that wouldn't survive first contact with constitutional analysis. She saw Bradley sitting with me. Her face went pale, then flushed with rage. She knew her own security officer was about to testify against her. At 2:00 p.m., we entered the courtroom. Federal Judge Sarah Morrison presided, civil rights specialist, former public defender, known for protecting constitutional liberties against government overreach. The HOA president, who thought she could operate a private police force, was about to face a federal judge who'd spent 25 years destroying unlawful detention operations. And Diana had no idea that body camera footage of Maya's 41-minute detention was about to play in federal court. The security director's private police force had 30 minutes before judicial destruction, and the restraining order that would end it was about to be granted. Judge Morrison reviewed the emergency motion for 30 seconds, then looked directly at Diana's attorney. "Counselor, I've read the pleadings. Your client's HOA security force handcuffed a 13-year-old and detained her for 41 minutes. Explain how that's constitutionally permissible." The HOA attorney stood. "Your Honor, HOA security was enforcing legitimate covenant restrictions. The minor was skateboarding in prohibited areas, fled when approached, and was briefly detained to verify resident status." Briefly, 41 minutes with a child in handcuffs is brief? The detention was necessary to ensure proper identification, and what legal authority does private HOA security have to handcuff anyone, much less a minor? The attorney hesitated. The HOA covenants grant the board authority to implement security measures. Show me where the covenants authorize detention and use of restraints. Section 22.7 permits security measures to protect property values and safety. Judge Morrison cut him off. Section 22.7 authorizes lighting, cameras, and access control systems. I don't see detention authority. Do you? The board reasonably interpreted security measures to include Private security personnel with handcuffs operating patrol vehicles, that's your interpretation of installing security cameras? I stood. Your Honor, if I may, I've brought the HOA's actual covenants. Section 22.7 provides no authorization for detention operations. Additionally, I have testimony from an HOA security officer willing to explain how this force operates. Proceed. Officer Bradley took the stand, sworn in, and began destroying Diana's defense. State your name and occupation. Tom Bradley. I was employed as HOA security officer for Lakewood Estates until this morning when I resigned. Why did you resign? Because I could no longer participate in unconstitutional detention operations that violated everything I learned in 28 years as a police officer. Describe what happened when Maya Chen was detained. Bradley's voice was steady, professional, damning. On the afternoon of her detention, Officer Morrison and I observed Maya skateboarding on the public sidewalk outside HOA property. HOA President Diana Prescott had previously sent email ordering increased surveillance of the Chen family and directing us to use full enforcement protocols if we observed any violations. Full enforcement meaning what? Physical detention, handcuffs, extended holding period in our patrol vehicle. For a 13-year-old skateboarding? Mrs. Prescott was clear that the Chen family required firm response because the guardian had challenged her authority. She told us to make an example that would discourage other residents from contesting HOA decisions. Judge Morrison leaned forward. The HOA president ordered you to detain this child as retaliation? Yes, Your Honor. When Maya tried to leave on her skateboard, Officer Morrison grabbed her. I applied handcuffs per our protocols. We held her in our vehicle for 41 minutes while she cried and had what appeared to be a panic attack. Did you notify her guardian? No. Mrs. Prescott's protocols don't require parental notification for detentions under 2 hours. 2 hours? You're authorized to hold children for 2 hours without calling their parents? That was the policy until this morning when Mrs. Prescott sent new protocols authorizing even longer detentions. I introduced Diana's email as evidence, the one authorizing detention of children as young as 12 for up to 2 hours. Judge Morrison read it, expression hardening. Mr. Chen, do you have additional evidence? Body camera footage from Officer Bradley showing the entire detention, Your Honor. The courtroom went silent as the video played. Maya skateboarding on the sidewalk, officers approaching in their patrol vehicle. Stop! We need to talk to you. Maya looking scared, trying to leave. Officer Morrison grabbing her arm. Bradley's voice. Jake, she's just a kid. Morrison. Prescott wants full enforcement. Cuff her. The sound of handcuffs clicking onto Maya's wrists. Maya crying, Please, I want my uncle. Please call my uncle. Morrison. You'll wait until we verify your information. Stop. Crying. 41 minutes of footage showing Maya in the back of the security vehicle, crying, hyperventilating, begging to be released. Bradley's voice off camera. We should call her guardian. She's having a panic attack. Morrison. Prescott said no contact until we complete verification. She stays until we're done. The judge watched all 41 minutes. When the video ended, the courtroom was silent. Judge Morrison looked at Diana's attorney. Does your client dispute this evidence? Your Honor, context is important. The minor was resisting lawful security. There's nothing lawful about handcuffing a 13-year-old for skateboarding and holding her for 41 minutes while she has a panic attack. Nothing. The judge turned to me. Mr. Chen, you're seeking emergency restraining order prohibiting all detention operations? Yes, Your Honor. prohibiting HOA security from detaining, handcuffing, searching, or physically restraining any resident pending full constitutional review. These operations violate Fourth Amendment protections, exceed HOA authority under governing documents, and constitute systematic civil rights violations. I'm granting the restraining order effective immediately. Judge Morrison's voice carried absolute authority. Lakewood Estates HOA security is hereby prohibited from detaining any person, using handcuffs or physical restraint, conducting searches, or claiming law enforcement authority. Security personnel may observe and report only. Any violation of this order will result in contempt charges and potential criminal prosecution. She looked directly at Diana. Ma'am, you created a private police force without legal authority, handcuffed a traumatized child, and systematically targeted young people of color. That's not HOA enforcement. That's a civil rights violation that will likely result in substantial damages. This court will not tolerate private organizations operating detention operations without constitutional constraints. The restraining order was entered at 3:47 p.m. Within an hour, every media outlet in Virginia had the story. Within 2 hours, national civil rights organizations were calling for state investigation. Within 3 hours, Lakewood Estates Insurance Company notified the board they were terminating coverage due to unauthorized law enforcement activities. Diana Prescott's private police force was destroyed in under 4 hours, and the HOA president had no idea the federal investigation was just beginning. The restraining order was served on Diana Prescott at 5:30 p.m. by a federal marshal who hand-delivered it to her home while news vans parked on her street. I was at my house with Maya when my phone started ringing with calls from reporters, civil rights organizations, and neighbors who'd seen the coverage. "Uncle Marcus, it's on the news. They're showing the video of me in handcuffs." Maya's voice was shaky, but stronger than before. "Everyone's going to see me, crying. Everyone's going to see what they did to you, and why it was unconstitutional." I pulled her close. "The judge said you were right to be scared, that what they did violated your rights. That's validation, sweetheart, not shame." The first call that mattered came at 6:15 p.m. from the Virginia Private Security Services Board. "Mr. Chen, this is Director Patricia Walsh. We've seen news coverage of the federal restraining order. We're opening immediate investigation into the licensing status of all Lakewood Estates security personnel." "What does that investigation involve?" "Security guards in Virginia are licensed for observation and reporting. They're explicitly prohibited from detention, arrest, or use of restraints except in immediate self-defense situations. If your evidence shows systematic detention operations, every officer who participated exceeded their licensing authority and faces potential criminal charges for unlawful imprisonment. I have body camera footage, emails, and testimony from Officer Bradley documenting 23 detention incidents over 18 months. Send everything to my office. We'll be suspending all involved officers' licenses pending full review. Operating a detention force without proper authority is a Class 1 misdemeanor in Virginia. Each detention could be a separate charge." The second critical call came at 7:45 p.m. from Lakewood Estates insurance carrier. "Mr. Chen, this is David Rodriguez, Risk Management Director. We've reviewed the federal court order and news coverage. Our policy explicitly excludes coverage for law enforcement activities, detention operations, and civil rights violations. Effective immediately, we're terminating Lakewood Estates liability coverage due to unauthorized security operations that created exposure we didn't underwrite for." "You're dropping the HOA entirely?" "We're notifying the board that coverage is void for any claims arising from security force operations." Additionally, we're recommending they immediately disband all security personnel and implement standard observe and report protocols only. Continuation of detention operations would make the HOA uninsurable. Perfect financial pressure that would force board action. The third call came at 8:30 p.m. from Jessica Torres, the neighbor who'd witnessed Maya's detention and called me that day. "Mr. Chen, I'm so glad you got that restraining order, but you should know, parents are organizing. We want Diana removed as HOA president immediately. There's an emergency board meeting called for tomorrow night. We're demanding her resignation." How many families are involved? At least 50 households, including the Morrison family, the Patels, the Rodriguezes, the Washingtons, every family whose children were targeted by security. We're all coming to that meeting to demand accountability. The board might not have authority to remove her midterm. Then we'll petition for special election. We'll sue. We'll do whatever it takes. Jessica's voice hardened with resolve. "My son is black, Mr. Chen. He's 14. He was stopped by those security officers 3 times in 6 months for suspicious activity, which meant walking to friends' houses in his own neighborhood. I've been afraid to speak up because Diana controls everything. But you stood up to her. You got a federal judge to shut down her private police force. Now the rest of us are finding our courage." At 9:15 p.m., Diana called my cell phone directly, first time we'd spoken since her detention threat. "You've destroyed this community's security, made us vulnerable to crime, turned neighbors against each other with your inflammatory lawsuit. I got a federal judge to prohibit you from handcuffing children. That's constitutional law, not inflammatory. Those security operations kept Lakewood Estates safe for 3 years. Property crime down 40%. Residents felt protected. White residents felt protected while families of color felt surveilled and targeted. That's not community safety. That's discriminatory enforcement. I never ordered targeting based on race. Security responded to behavioral concerns. Your officer testified under oath that you ordered increased surveillance of minority teenagers. Your own emails prove it. And 100% of detention victims being people of color isn't coincidence. It's systematic discrimination." The HOA president was silent for a moment. Then, "The board stands behind me. This lawsuit won't change HOA leadership. The board just lost their insurance coverage because of your unauthorized security operations. Tomorrow night, 50 families are demanding your resignation, and the state licensing board is investigating criminal charges against every officer who participated in your detention force. The board standing behind you means they'll share liability for constitutional violations. You can't threaten me with, 'I'm not threatening.' I'm informing you that operating a private police force without authority triggered federal civil rights liability, state licensing violations, and insurance cancellation that makes you personally responsible for damages. The federal lawsuit seeks $8 million. Your homeowner's insurance won't cover intentional civil rights violations. You'll be personally bankrupt." She hung up. At 10:30 p.m., I received email from the HOA board secretary. "Emergency meeting scheduled tomorrow, 7 p.m. to address security operations, insurance coverage loss, and community concerns regarding President Prescott's leadership." At 11:00 p.m., the local news aired interview with Officer Bradley explaining why he resigned and testified against Diana's security force. "I handcuffed a 13-year-old girl who'd lost her father to police violence, held her while she had a panic attack, all because the HOA president ordered retaliation against a family that challenged her authority. I couldn't do it anymore. Some paychecks aren't worth your soul." The interview went viral within hours. By midnight, the hashtag #JaredLakewood Detentions was trending with thousands of comments condemning Diana's private police force. The HOA president, who'd spent 3 years building power through intimidation, was being destroyed by federal court order, state investigation, insurance cancellation, and community uprising. And she still didn't know that the civil rights lawsuit seeking $8 million would be filed within 48 hours. Diana thought the restraining order was the consequence. It was just the beginning. The emergency HOA meeting drew over 300 residents, the largest attendance in Lakewood Estates history. The community center was packed with families whose children had been targeted, neighbors who'd witnessed discriminatory enforcement, and residents demanding accountability for Diana's unconstitutional security operations. Media cameras lined the back wall. Civil rights organizations sent observers. Virginia state legislators attended after the detention story went national. I sat in the front row with Maya, Officer Bradley, and the 12 families whose teenagers had been detained over 18 months. Diana sat at the board table, flanked by her attorney, face composed, but eyes showing the strain of someone watching their authority collapse in real time. The interim board chair opened the meeting with visible discomfort. We've called this emergency session to address concerns about HOA security operations, recent federal court orders, and loss of liability insurance coverage. The floor is open for resident comments. Jessica Torres stood first, holding her 14-year-old son's hand. My son Elijah was stopped by HOA security 3 times in 6 months. 3 times for walking in his own neighborhood. Security demanded ID, questioned where he was going, made him feel like a criminal in the community we pay dues to live in every time the reason was suspicious activity. Every time what was actually suspicious was the color of his skin. She pulled out her phone, showed photos. Here's Elijah walking to his friend's house. Security stopped him. Here's Elijah riding his bike to the park. Security stopped him. Here's Elijah taking out our trash. Security followed him back to our house to verify residence. Mrs. Patel stood next, voice shaking with controlled fury. My 14-year-old daughter was detained for sitting in the park with friends. Security said they were loitering. White teenagers sit in that same park every day without anyone questioning them. But my daughter, who's lived here since she was 6 years old, was treated like a trespasser in her own community. Mr. Rodriguez stood, his 16-year-old twins beside him. Security confiscated my son's basketball for excessive noise at 3 p.m. on a Saturday. Made them leave the community court they've used for years, threatened them with trespassing charges if they returned. We sold our house 3 months later because my children were afraid to play outside. One by one, 12 families testified about children detained, stopped, questioned, searched, and driven from community spaces by Diana's security force. Every detained child was a person of color. Every family described the same pattern: normal teenage activity criminalized when performed by non-white youth. Then Mrs. Washington stood, her 13-year-old son trembling beside her. Security stopped my son, claimed they smelled marijuana, searched his backpack without consent. Found nothing because there was nothing. But they photographed his ID, recorded his information, treated him like a suspect. He was walking to a friend's house with his math homework. Her voice broke. My son asked me last month if we could move because he's scared of the security officers. A 13-year-old afraid in his own neighborhood because HOA President Prescott decided black children are suspicious. Officer Bradley stood, no longer in uniform, speaking as a resident rather than employee. I worked HOA security for 18 months. I participated in every detention these families described, and I'm here to tell you, none of it was legitimate security work. It was systematic targeting of youth of color based on discriminatory orders from Diana Prescott. He turned to face Diana directly. You sent emails ordering increased surveillance of minority teenagers. You created protocols authorizing detention of 12-year-olds for 2 hours without parental notification. You personally directed Maya Chen's detention as retaliation, and when I objected, you threatened my employment and licensing. The room erupted, residents shouting questions, demanding Diana's resignation, calling for her removal. The board chair called for order, then addressed Diana. Mrs. Prescott, do you have response to these allegations? The HOA president stood, attempting to project the authority that had intimidated residents for 3 years. I implemented security measures that protected this community, reduced property crimes, maintained standards that preserve our property values. The federal court's decision was based on misunderstanding of HOA security authority. The federal judge called your operations unconstitutional civil rights violations, the chair interrupted. Our insurance company terminated coverage because you created unauthorized law enforcement activities. The state licensing board is investigating criminal charges. How is that misunderstanding? Security operations were necessary to address behavioral concerns and maintain family-friendly environment. Family-friendly? Mrs. Torres's voice cut through. You handcuffed children, traumatized teenagers, made families of color feel unwelcome and surveilled. That's not family-friendly. That's racist enforcement disguised as security. The crowd erupted again in support. Diana's attorney stood. My client denies any discriminatory intent. Security operations responded to legitimate concerns about 100% of detentions targeted people of color, I said, standing. 23 incidents, 23 non-white victims, 0 white teenagers detained despite identical activities. That's not legitimate security. That's systematic racial discrimination. The board chair looked at Diana. Mrs. Prescott, the board has reviewed the federal court order, insurance cancellation, and community testimony. We're calling for vote on your immediate removal as HOA president. You can't remove me mid-term without cause. Operating an unauthorized security force that violated residents' constitutional rights, created $8 million in potential liability, and lost our insurance coverage as cause. The vote was called. 6 board members present. Vote to remove Diana Prescott as HOA president, 5-0, with 1 abstention. Diana's 3-year reign ended in unanimous condemnation. The security director who'd built power through intimidation was removed in disgrace while 300 residents watched and cameras recorded. She stood, face pale, and walked out of the meeting without another word. The community that had lived in fear of her private police force was finally free. Diana Prescott's attorney contacted me 6 weeks after her removal from the HOA board with a settlement offer. My client is prepared to settle all civil rights claims for $850,000. She'll agree to permanent ban from any HOA leadership position in Virginia, public acknowledgement that security operations exceeded authority, and cooperation with ongoing state licensing investigations. I reviewed the offer with the 12 families whose children had been detained. It's not just about money, Mrs. Torres said. It's about making sure no other community lets someone create a private police force that targets children of color. The settlement includes systemic reforms, I explained. Diana pays damages from personal assets since insurance won't cover intentional civil rights violations. Virginia legislature is drafting new law explicitly prohibiting HOAs from operating detention forces, and the state licensing board is implementing new restrictions on security guard authority. Mrs. Washington nodded. My son can finally play outside without fear. That's what matters. We accepted the settlement. $850,000 distributed among affected families. Diana personally bankrupted by the civil rights violations she'd committed. But the real victory went beyond financial compensation. 3 months after the federal restraining order, Virginia governor signed into law the Lakewood Accountability Act, legislation prohibiting HOAs from hiring security with detention, arrest, or physical enforcement powers. Security personnel limited to observation and reporting only. Criminal penalties for HOA officials who create unauthorized police forces. The law was named after Lakewood Estates, ensuring Diana's constitutional violations became the precedent that protected residents statewide. Officer Bradley found new employment with a legitimate security company that operated within legal bounds, his testimony having protected rather than destroyed his licensing. The 12 families whose children were targeted received formal apologies from the new HOA board and assurances that discriminatory enforcement would never return to Lakewood Estates. Most importantly, Maya returned to skateboarding at the basketball court. I watched her from the same bench where I documented discriminatory stops months earlier, seeing her practice tricks with the confidence of a teenager who'd learned that standing up to unconstitutional authority, through legal channels, not violence, was how you honored those lost to authority abuse. She landed a difficult trick, looked over at me with a smile that reminded me so much of her father. Uncle Marcus, I did it. Did you see? I saw, sweetheart. Your dad would be so proud. Not just the skateboarding, I mean standing up to them, using the law instead of being scared. Maya rolled over to the bench. You taught me that even when people have uniforms and badges and look official, they still have to follow the Constitution. And if they don't, there are ways to stop them. That's exactly what your mother wanted you to learn when she asked me to keep you safe. You did keep me safe, not by preventing them from grabbing me, but by making sure they faced consequences and couldn't grab anyone else. My sister Rachel called that evening while Maya practiced at the court. Marcus, I saw the news about the settlement and the new Virginia law. You didn't just protect Maya, you changed the system. I used the same constitutional expertise that won your husband's case. But this time, we got justice before anyone died. That's honoring his memory, using what happened to him to prevent it from happening to other families. Her voice strengthened. Maya told me she's not having nightmares anymore, that she feels safe skateboarding again. You kept your promise. You protected her and made sure she could heal. The basketball court where Maya had been grabbed transformed from site of constitutional violation into symbol of civil rights enforcement. Other teenagers, Black, Latino, Asian, white, all played there freely now, without fear of being detained for existing in their own neighborhood. Diana Prescott sold her Lakewood Estates home at a loss 3 months after the settlement, unable to afford the property after personal bankruptcy from civil rights damages. Her security officers who'd participated in detentions faced state licensing suspensions and criminal charges for unlawful imprisonment. The HOA that had enabled her discriminatory enforcement implemented comprehensive reforms, non-discrimination policies, prohibition on targeting youth based on race, independent oversight of all enforcement actions, and community education about constitutional protections. Property values recovered as Lakewood Estates regained reputation as genuinely welcoming to diverse families. But the real measure of victory was simpler. Maya skateboarding at the basketball court without fear, playing in the space her father never got to see her use, processing grief through movement instead of being criminalized for it. The pink skateboard that had been cited as a violation became symbol of healing, resistance, and constitutional rights protected. One afternoon, a new family moved into Lakewood Estates, biracial couple with a teenage son who loved basketball. I watched the teenager approach the court hesitantly, looking around as if expecting to be stopped. Maya skated over to him. "You play?" "Yeah, but is it okay? I don't want to get in trouble with security or anything." "There's no security anymore, just regular HOA, stuff like lawn care and pool hours. You can play whenever you want." The teenager smiled with relief. Maya understood completely. "Really? No one's going to question why I'm here?" "Nope. Because someone fought to make sure kids can use community spaces without being treated like criminals." She pointed at me. "That's my uncle. He's a civil rights attorney. He destroyed the people who tried to make this neighborhood unsafe for families like ours." I thought about the promise I'd made to my sister, to keep Maya safe, to prevent authority abuse from traumatizing her again. I'd failed to prevent her detention, but I'd succeeded in ensuring it never happened again. Diana thought HOA authority and uniformed officers gave her the right to handcuff children. A federal judge taught her that constitutional protections don't negotiate. And a niece who'd lost her father to unlawful detention learned that legal systems can protect as well as harm, when used by people who understand both constitutional law and the communities that law is meant to serve. If you want more stories about uncles who use every constitutional expertise they have to protect their nieces from authority figures who abuse power, hit subscribe right now. Share your story in the comments about standing up to HOA overreach or protecting children from unlawful detention, and let me know where you're watching from. Because sometimes the greatest victories come from refusing to let anyone, HOA president or otherwise, traumatize your family and escape accountability. Diana grabbed my niece thinking she had authority. A federal judge showed her she had liability. And Maya skates free.